Section 2. Registrable marks and legal requirements for registration. Generally speaking, the legal rights in a mark can be established in two ways. Number one, based on use of the mark in commerce, or number two, through registration. In some jurisdictions, for instance, the United States, it is possible to own a trademark by means of being the first to use it in trade and make a continuous use of the mark thereafter. The manner of use required under legislation usually includes, for instance, number one, to use it in commerce, and number two, in a way that permits consumers to distinguish your particular goods and services from those of another producer. It means that in order to establish a legal right to exclude others from using a particular mark, it is not enough just to use a mark, for instance, as a page in your book or for decoration purposes. It must be used as a trademark. What is a use as a trademark? Quite simple. The mark is used to indicate the source of the goods or services placed on the marketplace. In China, exclusive rights in the mark cannot be established through continuous use because we have a national registration system. The trademark law of China majorly protects registered marks. It's highly recommended that any mark in China should be registered with the Trademark Office of China. But it is not compulsory, of course, to use a mark in commerce without registration. You can use a mark for your business without the registration. It's not illegal. It's completely legal. That's your business. But it's highly risky. Without registration, it means you don't have exclusive rights for the use of that mark. Anyone else will be allowed to use that mark. Number two, it could be possible that somebody else would register that mark with the trademark office and become the trademark owner. In that case, your right to use that mark will be essentially limited. However, prior use of a trademark in commerce may establish some privileges. For instance, number one, prior use of a mark without registration may establish a defense against the infringement accusation. You use the mark for your commerce, for your business for many years without registering it, and then it became a trademark registered by someone else and got sued for trademark infringement. In that case, you may raise so-called prior use defense against infringement. Number two, prior use may give rise a privilege to maintain the rights to use it within the original scope, which means you have been using the mark for many years for your business without registration, and then one day it's got registered by somebody else. What is going to happen? So you have to stop using it for your commerce? No, you don't have to. You can keep using it as a mark for your business, but it must be within the original scope. For instance, you've been using the mark for selling wine in Shanghai. You cannot expand that use to selling to the selling of wine in Jiangsu province or to the selling of other products. Number 3, using a mark without registration may give you a chance of legal protection under trademark law, provided that the unregistered mark becomes well known after many years of continuous use. It means the mark became an unregistered, well-known mark under the trademark law of China. As we mentioned earlier, for well-known marks, it may benefit stronger protection. Under the current Chinese trademark law, a trademark become well-known, but it was not registered, can be protected to an extent. We will be back to the protection of unregistered well-known marks in the following sessions. Registrable marks and legal requirements. As a general principle, to register a trademark, the sign you choosing must be satisfying the following requirements or conditions. Number 1, the sign or the mark being or to be registered must be in permitted forms. Number 2, the mark chosen by you not excluded from registration. The trademark law clearly say that some rights, or some marks or some forms of marks, or the marks under some specific circumstances cannot be registered. It even cannot be used as a trademark. Number 3, it's not in conflict against any existing trademark or other legal rights. For instance, if you try to trademark the logo or the image of Michael Jordan, of course, that would be very unlikely a successful registration, because Michael Jordan may argue that, look, that would be infringing or on my rights of my personal image. So if the registration or the marks used for registration is in conflict with any legal rights, not just any existing registered mark, you cannot trademark and the trademark owned by another company, of course. You cannot trademark a logo or an image of a person without permission of that person. You cannot trademark a painting, for instance, created by that author without his or her permission. That would be in conflict against his or her copyrights. Number 4, the marks to be registered must be distinctive. As we mentioned earlier, being distinctive is a major requirement for a mark to be registered. Actually, that's a fundamental nature for a mark to be functioning as a mark, as an identifier of a mark, or identifier of goods or services. So the theory concerning distinctiveness of a mark is a major topic of our lecture in the following session. Number 1, permitted form. Well, the permitted form, as you may say, All kinds of trademarks around us in daily life. When you're walking on the street, when you are watching TV, even when you just take a look at all those buildings outside on the streets, you will see all kinds of advertisements or flyers so bearing logos, marks. So these marks can be, for instance, the latest names of somebody, numeral, or even sound. Well, so the scope of permitted signs has been expanding from those traditional trademarks such as letters, names, or devices to sound, scent even. Those non-traditional trademarks, for instance, sound, permitted in the US, and now it's permitted in China. Smell, permitted in the US and Europe, but not in China. Touch, when you touch the products, that feeling of touch. You say, well, without taking a look at, without opening your eyes, if you do have eyes to see, wow, that's a product from that company. You just feel it, you touch it, you say, you, that feeling will tell you that definitely from that company. I've been using for many years. So those are called non-traditional trademarks are quite rare, and many countries even today still limits what can be registered as a trademark. For instance, smell and touch not allowable for registration even in China today. Why? Because traditionally, it was believed that only signs that are visually perceivable or can be represented graphically could be subject to registration and use as a trademark. Right? If people cannot see it, how can it how can it enable people to identify the source of goods or services? Well, the 2013 amendment of China's trademarks adds sounds to the scope of registrable marks. Article 8 of Chinese trademark law provides that any sign that distinguishes that is capable of distinguishing the goods of a natural person, legal person, or other organization from those of others, including any word, device, letter, number, three-dimensional sign, color combination, sound, and the combination thereof may be registered as a trademark. Those are all accepted forms of sign for registration with Chinese Trademark Office. So sound for sure accepted for registration, but how about single colors? You say in the definition it says that it's a color combination. It's a combination of more than one colors. But how about say the single color? Red, just red. And scent, for sure not allowable for registration. How about moving images? Well, that's a question mark. Why? Because the law say that um, any sign that's capable of distinguishing goods or services of one undertaking from those of another, of other undertaking, um, could be registered. For instance, including word, device. You see, the wording is including. It can be argued that those forms of signs enumerated under the law just for just not exhaustive and just for illustrative purpose, right? It does not exclude any other forms of sign enumerated here. But others argue that, well, sorry, that enumeration on the Chinese law is exhaustive. If it's not enumerated here as a form of a permissible sign registrable for trademark, it should be rejected. So the sound used as trademark, as we mentioned earlier, were rejected for registration for many years traditionally. The most famous of all the big Hollywood studios, MGM, always began its movies with an image of the company lion giving a roar, which sounds like this. Okay, so what is the trademark registered or owned by MGM? The moving image, the line, or the roar of the line, the sound, or the entire logo with the line, stay still. So that could be, and also MGM, right? That's all marks. But here, what we are talking about is the roar of the line. So that's a sound trademark. Anyone sitting in the cinema without opening his or her eyes, listening to the roar of the line would definitely have a clue that, wow, this movie is produced by MGM. So a sound trademark is a trademark where sound is used to perform the trademark function of uniquely identifying the commercial origin of products or services. In recent years, sounds have been increasingly used as trademarks in the marketplace. However, it has traditionally been difficult to protect sounds as trademark through registration. Why? As we explained earlier, a sound was not considered to be a trademark as it's not visible, not perceivable to mankind. But this issue was addressed by the WTO agreement on trade-related aspects of intellectual property, WTO TRIPS agreements, which broadened the legal definition of trademark to encompass any sign capable of distinguishing the goods or services of one undertaking from those of other undertaking. So following this definition, the trademark law of China also adopted a definition accepting the registration of a sound as a trademark. And what is this one? Is this what is this? Is this a trademark? Are we talking about another form of trademark here? With eggs of something, right? But it's definitely not the egg. If you are Chinese, you say, oh, that looks like a salted eggs of ducks. Okay, that's not duck's egg. Much smaller, and the eggs of ducks is not this kind of blue, right? This is an egg of a kind of bird, robins. Robins are popular birds for their warm orange breast, cherry song, and early appearance at the end of winter, and they can be found easily throughout Europe, Western Asia, and parts of North Africa, but not here in China or North or Eastern Asia. Robin eggs have a distinct blue color that is commonly referred to as eggshell blue or robin blue. Or the blue, well, that blue is very famous. Why? Because of this lady, or it's because of this. Yes, robin egg blue is also called Tiffany blue. It's being used as a major color, or if not the only color, for Tiffany for selling jewelries. So anyone, well, if not any, at least many consumers, ladies, girls, when they see this packaging, you see the color, the blue, that's color, and then they will say, okay, I see that must be something from Tiffany. You don't have to see the logo. There's no logo, no trademark on that packaging, that box, right? But that's for sure to many people. Is something from Tiffany. Can the single color, you see, the single color in the case of Tiffany Blue and Tiffany's products, Tiffany services, you say, well, in this case, a single color, the blue, is functioning as a trademark, is functioning as an identifier of the source of this product, something in the box from Tiffany. More examples. For example, here, this one, Barbie, the doll. The Barbie doll is always in the very special kind of red or pink. I don't know, red or pink. I'm not a fan of Barbie. Well, this is a trademarked color for Barbie. So you say Barbie doll is always in this color. And this color purple for a telecommunication company, Verizon, in the US. And the color purple for chocolate offered by Cadbury for over 2 decades. The color purple was registered as a color trademark actually in Europe, and it's been used by Cadbury for the chocolate products for over 20 years. However, last year, this trademark was denied by the UK Court of Appeal after many proceedings. Um, the court was of the opinion that the color purple had no distinctive character at all and was too broad for a range of goods. This judgment was quite surprising to the market actually. Why? Because and there have been quite a lot of single color trademarks being protected and acknowledged by the courts in both European countries and US courts. But here the courts overruled the decision of lower courts, deciding that um, Cadbury's color purple trademark with a Pantone reference 2685 was not protected under trademark law. And the bright red, a single color for women's shoes, was registered for trademark protection in many countries and many litigations around this trademark. including China. And this one is decided by courts in the US in the year 2011 to 2012. The plaintiff sued and the defendant is a YSL, alleging trademark infringements of and it's a very famous single color trademark, the bright red on the soles of women's shoes. And this case we will discuss further in the following sessions. And the courts basically rule that the single color mark can be registerable, protectable, as long as it's functioning as an identifier of goods or services. Well, the lower courts ruled against the trademark owner, Lupton, on the grounds that this color is not distinctive and shall not be allowed for exclusive use, given the fact that it would limit the free choice of designers and it would be detrimental to the fashion industry. And one more case here. So you already know that there have been numerous trademark registrations for specific colors in the past, such as for the color um, turquoise used by Heinz for its baked beans, the distinctive red color used by Christian Louboutin on the soles of its shoes, and a specific color owned by Orange for telecommunication services, and the color pink owned by Verizon in the US for telecommunication services. And here's one more case related to the lovely, cute, and sweet meanings. The color yellow of meanings in the movie Despicable Me was created by Universal Studios and Pantone. Pantone is a company famous for its Pantone color reference system and also specialized in creating new colors. And the color of meanings is called or is named as meaning yellow. Well, you may say, wow, that's just a yellow, right? What's the difference? Look, there could be hundreds of yellow, the different kind of yellow, right? And here, for instance, on the slide, say the blue, this kind of blue here, bearing the Pantone color reference 285 as a very specific kind of blue, and the color yellow on the right, Pantone reference number is 800 is also a very specific kind of yellow, which is different from a meaning yellow, where although they all look yellow. So Universal Studios trying to trademark Pantone meaning yellow. Well, if a single color is trademarked, it means that it's basically owned exclusively by the trademark owner. Anyone else without permission cannot use that trademark for that specific goods. Well, so in the case of Louboutin, it means even you were a designer for shoes, you can pick up red for the soles of your shoes. But that's surprising. Of course, that's also the concern of the courts, trying to strike a balance between the interests of the trademark owner here and the interest of the fashion industry and individual designers. The Pantone color system is very important for fashion industries, for printers and designers. If you were a designer or printer, you would be very familiar with this system. And here is a very brief introduction to the Pantone color system.
First of all, Pantone is a standardized color matching system that designers and printers use when we need to ensure color consistency. The most commonly used Pantone system is what's known as the solid palette system. Now, there are other Pantone systems, and these include CMYK, there is a metallics range, there are pastels, and there's also a home and fashion range. But for this video though, we're going to be sticking with the most commonly used one, which is the Pantone solid system. Let's grab a guide. This is a Pantone color guide, and this is the Pantone solid color guide. As you can see, there are quite a few colors in here. Now, every color in this book has a color reference. So when you have your logo designed, your designer will specify one of these or multiple, depending if it's a multicolor logo. They would specify a specific number for each Pantone color that they use in your logo. Now, for example, with the Pixels Inc. logo, my color reference for Pantone is, let's try and find it, should have put a post-it note in here, is 186. So Pantone 186 is the red that I use for my branding whenever I specify it for printing.
So a single color to be trademarked for a specific products to many courts is not possible, or it must be carefully considered. To many courts, a single color is not distinctive to be used for any products at the first place. But the US courts in recent years have been following the concept that a single color could be inherently distinctive for the use of for being used as a trademark for some products. Well, we will be back to the discussions on the distinctiveness of a single color in the following sessions and case discussions. Number 2, the sign or mark to be registered must not be excluded from registration. And here on the current Chinese trademark law, we have two categories of signs prohibited from being registered. Group 1, signs prohibited from being used as trademark. Of course, it will be denied for registration. You even cannot use it. How can you manage to trademark it? These signs include signs that represent or exaggerated manner or deceptive in nature against the moral concerns or detrimental to morality and public interest or having any undesirable effects, or the names of an administrative division, for instance, Shanghai, Beijing. You cannot use Beijing as a trademark for your product. And for instance, national flag of a country of China, of any other country, or the name of a foreign country, or the name of a foreign place, a foreign mountain, well known to the public. Category B, those signs prohibit from being registered as trademark. You see, just the trademark office will not accept for registration, but it's okay. You can use it as a trademark for your business. No one care. But it's quite risky. Why? Because sometimes it just means nothing. It's meaningless, pointless to use it for your products. For instance, if you use the image of a crab for selling crab, right? It's not distinctive at all, right? No one knows that you're just and it can only tell people that you are selling crab, but so what, right? So you are not giving a brand to your crab, to your products, or just like a Chinese character or water or mineral water for your products, selling mineral water, or cheese for selling cheese, right? It's just a descriptive of what you are offering on the marketplace. It's a generic term. Then it is okay. You can just keep using it as long as you're not going to register it, because your registration will be denied. Those signs include signs consisting only of the generic names of products, of anything, appearance and modules of products, and signs consisting of direct representation of the quality, primary raw materials, functions, intended purposes, the weight, quantity, or other characteristics of the products concerned. It means, for instance, so you're selling Apple, right? You're sellers for selling Apple. You say, well, uh, the brand I'm using for selling Apple is the image Apple, right? Well, that or just say the word Apple, right? You're not telling your potential clients or consumer anything, right? You're not telling your potential consumers who was the provider of these products. It's merely telling people that you are selling Apple. Yeah. So any sign that's merely describing the nature of this of the products, or the raw materials of the products, or functions of the products. You cannot trademark, for instance, a telephone for selling telephone, or smartphone for selling smartphone. Number three, not preempted by any existing trademark or any existing legal rights owned by another person or another legal person, the company. It means the mark to be registered must not be in conflict. For instance, the copyrights owned by someone else, or any civil rights of somebody else, or the mark looking for registration is similar or identical to a trademark owned by another one. And there is a very interesting case here. Mr. Xie, a Chinese citizen, went to the trademark office in order to register bond 007 in class 10. products. Well, Bond 007, that's I think to anyone, that's the name of the key character in a very famous movie. The title of the movie also uh, Bond or 007, right? So the producer, uh, the publisher of the movies, the studio, of course, would stand up and say, no, how can you register 007 for any class of goods? Because that's the title of our movie. That's the names or key of our um, of the characters in our movies. It's so famous, right? You are trying to hijacking of rewriting the reputation of our movies. So the producer of 007 movies opposed to the registration by the plaintiff here or by the applicant here, Mr. Xie. Well, it's quite interesting case because the trademark office and then the TRAB, the courts and the courts on appeal were very struggling to decide whether this registration is deniable or not. The publisher of the 00 movies filed an opposition to this trademark application based on many grounds. Number one, it's claimed that this application might be detrimental to its copyrights in the movie as 007 is the name of the movie. And in addition, Bond 007 is the name of the key characters in the movies. Well, this has been denied by the courts because under Chinese copyright law, the title of a work is not the work itself, right? The title cannot be protected as a work. But the entire movie, of course, protected as copyright work. But the title of the work itself is not the copyright work. Number two, it's been claimed that this application might be infringing the trademark owned by the publisher of 007 movies because the applicants also registered 007 and image trademark and the trademark James Bond in classes 28, 41 in 2001 in China. Well, these might not be established because you see Mr. Xie trying to trademark 007 in class 10, whereas the trademark on 007 registered by the publisher of the 007 movies is in classes 28 and 41, so different classes. So the trademark registered in different classes are different trademarks. Well, that could be one exception. It could be possible that this application might be infringing the trademark owned by the publisher of 007, provided that 007 and the image mark of 007 or James Bond can be acknowledged by the courts or by the trademark office as well-known mark in China. But at that time, it's quite obvious that James Bond or 007 are not well known at all for classes 28 and 41 products. Number three, It's also been claimed that the use of 007 in Class 10 products might be detrimental to the interests of the claimant because Mr. Shea trying to use this trademark 007 James Bond for Class 10 products, which includes products such as condoms. So the claimant argue that, well, that's against the morality. It's not moral, right? It's detrimental to the public interest. Well, but that's also denied by the courts in the end. So here, the trademark law of China says that any trademark registration shall not be in conflict with any existing prior rights. But it's not clear what kind of legal rights may fall within this definition. Any legal rights. And what's a legal right exactly here with the publisher of the 007 if those claims number 1, 2, 3 proposed earlier all being denied by the courts cannot be established under Chinese law. To the very end, the Beijing High Court determined that this trademark application filed by Mr. Xie was in violation of Article 37 of the trademark law, which provided that no prior or pre-existing rights shall be damaged when a trademark registration is granted. And here in this case, the pre-existing rights protected is a right subsisting in the reputation of the film 007 and James Bond. Well, this actually quite controversial decision because under current Chinese law, there is no clear or expressive definition of any kind of rights which may subsist in the reputation of work, or for instance, the reputation of a key character in a movie, for or to be used by a third party in commerce, or basically trying to free-riding the reputation of the famous James Bond character or any other characters, or even celebrities. Number 4, distinctive. To be accepted for registration with the trademark office, the sign or the mark must be distinctive. The basic function of a mark is its function to distinguish the product or services of one enterprise from the products or services of another enterprise. From that function, it follows that a trademark must be distinguishable among different products. Therefore, a registrable sign must be distinguishable and capable of distinguishing the goods or services of one undertaking from those of others. The distinctiveness of the mark refers to how easily customers identify a trademark with the associated products. When you see the brand Lenovo for laptop computers, what's in your mind is not the nature of the products, but the source of the products. A sign could be inherently distinctive or becoming distinctive after many years of use and acquired secondary meaning. Inherent distinctiveness. plus acquired secondary meaning or acquired distinctiveness are the possibilities enable the mark to be accepted for registration. A mark can be inherently distinctive if it's fanciful. Fanciful marks are invented words or signs without any real meaning or completely made up. For instance, Lenovo for computers, Exxon or Kodak. These words were created, invented, or made up by the trademark owner. So it can be used for any classes of good and it's inherently distinctive. Simply because it's meaningless, referring to nothing, not to the quality or the nature uh, or the name or generic name of any products. So it's inherently distinctive for any products. Fanciful trademarks. Number two, arbitrary trademarks. Arbitrary marks are words or signs that have a meaning, but that but one that has no logical relationship to the product they advertise. For instance, Apple for computers, Blue Diamond for nuts, Green Leaf for insurance companies. It means the strength of distinctiveness of an arbitrary sign depends on the classes of products for which it will be used for. Apple for computers is a very strong product. It's a very strong brand, a very strong trademark with very strong distinctiveness. But it's not distinctive at all for selling apple juice. Number three, suggestive trademarks. These are marks that hint at nature, the quality, or attributes of the products, but do not describe these attributes. For instance, Best Buy for supermarkets, American Standard. The strengths the strengths of distinctiveness of these marks, fanciful, arbitrary, suggestive, and even descriptive and generic terms, is getting weaker and weaker. So the protection available under trademark law is also getting weaker and weaker. Descriptive marks are trademarks or marks which merely describe some features of the products in question, like its quality, type, efficiency, intended purpose, value, raw materials, location for provision of services. Descriptive terms have little distinctiveness and so are not eligible for protection unless it can be shown that distinctive character has been established over time through extensive use in the marketplace. But on the bottom, the generic term or generic signs cannot be trademarked. Generic signs are words or signs that name the species or objects to which they apply. For instance, mineral water, just water, or ocean, or chair, window, building. These are totally without distinctiveness and are not eligible for protection as trademarks because giving them protection would deprive competitors of the rights to refer to their products by name. For instance, if Apple for selling fruit or apples trademarks, it means that any sellers except the trademark owner of Apple and cannot use Apple to describe what they are selling. So the strengths of distinctiveness of a mark may be class dependent. As we explained earlier, for some marks or signs that could be very strong um, for this class of products, but not for other classes of products. For instance, Red Bull for drinks that's okay, but Red Bull for selling bowl or selling a cow might not be distinctive enough. So, what is distinctive in relation to one class of goods may not be so in relation to another class of goods. For instance, Apple for um, selling computers, that's fine. And so the distinctiveness of a mark could be class dependent. Under the so-called Nist classification system, the Nist agreement, this is an international classification of goods and services applied for the registration of marks internationally. The 2016 version of the Nist came into force in 2016. The system groups products into 45 classes. From classes 1 to 34 includes goods, and classes 35 to 45 embrace services. And this is a very interesting case between two apples. In about 30 years, the two apples were suing each other. The apple with a bite and the apple in green. Between 1978 and 2006, there were a number of litigations between the Apple Corporation, founded and owned by the Beatles, and the computer manufacturer Apple Computer, founded by Steve Jobs, over competing trademark rights. In 1978, Apple Corporation filed a lawsuit against Apple Computer for trademark infringements. The suit was settled in 1981 with an undisclosed amount being paid to Apple Corporation. As a condition of this settlement, Apple Computer agreed not to enter the music business, and Apple Corporation agreed not to enter the computer business. However, in September 2003, Apple Corporation sued Apple Computer again, this time for breach of contract, because you may remind yourself of what was happening in 2003. In 2003, Apple Computer launched a new line of products, iTunes. iTunes is an online platform distributing music. So Apple Corporation was of the view that this is a breach of contract settled and concluded in 1981. Apple Computers and Steve Jobs this time again agreed to pay a lot of money to Apple corporations. The final deal was that Steve Jobs managed to by the entire ownership of Apple Corporation, owned by the families of Beatles, because members of Beatles at time had passed away. Therefore, Apple Computers now owns Apple Corporation, and they trademark in the green apple. Through the fight between the two apples, you can see how the distinctiveness of a mark is class dependent. The image of an apple with or without a bite can be a strong trademark for selling digital devices, but not for fruit apple or apple juice. In other cases, the distinctiveness of a mark can be too weak to be accepted for registration at the first place, but after a period of use in commerce, it gets stronger and stronger so that the mark will obtain secondary meaning and be accepted for registration. Those marks, for example, descriptive marks which closely describe the quality and or origin or the raw materials of the underlying goods or services, such as American Standard for toilet products, Best Buy for supermarkets, and the leadership Xiaofeiyang for restaurants. Other words that are viewed primarily as surnames or families or individuals, for instance, there for computers, and words that are viewed primarily as geographical terms by consumers. The distinctiveness of these marks has been or can be acquired through use after it gains secondary meaning. A mark has acquired secondary meaning when in the minds of the public. The primary significance of a product feature is to identify the source of the product rather than the product itself. For instance, when we see the trademark there, it's not about the guy whose name is there, is to identify the origin, the supplier of the products, computers. When you see the bottom of the woman's shoes in red, what's in your mind primarily is not how beautiful the color is, how beautiful, how nice the shoe is. What's in your mind is that, wow, that's the shoes from that producer or from that manufacturer, from that service provider or product supplier. In China, the story of a little sheep, or literally little fat sheep, 小肥羊, might be a good example for you to understand how a weak mark may grow stronger so that the trademark office eventually accepted for registration. In 1999, Bottle Leadership Restaurant tried to get the marked leadership registered, and it was denied by the trademark office. The trademark office was of the view that leadership and the mentorship lamb is the key raw material for hot pot, and offering lamb as a key food for hot pot is a common practice and the key nature of any hot pot restaurant. So the restaurant's application for a trademark for Class 45 was rejected by the trademark office of China. However, the applicant here and this restaurant and keep using leadership as the trademark for the restaurant. A few years later, the applicants went back to the trademark office of China with strong evidence, um, trying to convince the trademark office that, well, look, if you ask anyone on the street what the little ship is, anyone would say, well, that's one of the best restaurant for hot pot, and the lamb offered by that restaurant as one of the best choice of any hot pot restaurant. Eventually, the trademark office of China was convinced. So, through intensive using and advertising, little lamp had become distinctive enough to distinguish the source of the goods of the restaurants. And consumers can distinguish the hot pot catering services from different sources. Therefore, the restaurant managed to get Little Fat registered as Little Fat ship, Little Ship has acquired a secondary meaning through the use and advertising by the restaurant. What's more, a mark's distinctiveness might be lost or diluted if used improperly. It means, at the first place, it is a very strong mark, a very distinctive trademark. But after many years of use, well, it's not distinctive at all. It's getting weaker and weaker. Generally speaking, a mark can lose distinctiveness in two ways. Number one, used by a competitor as a mark for a sufficient period of time that the public no longer associates the mark with the original owner. Number two, becomes a generic term, namely used as the name of and the items, the article offered on the marketplace. For instance, thermos or cell phone or aspirin. This type of trademark, such as the thermos or cell phone chip for cars, is getting weaker and weaker, not because it's not being used as a trademark on the marketplace. On the contrary, it's become generic because it's being so widely used and become a common name to designate the relevant goods or services. In such instances, the trademark will not be registerable, or if it is registered, it will be cancelled for registration. Um, some marks retain trademark protection in certain countries despite being declared generic in others. So whether it's being a generic term, for instance, thermos, and it's been declared generic term in the US, but it might not be a generic term in another country in other language. And another example is Jeep, the car. Jeep car Jeep is a trademark for many years for SUV, that's kind of vehicle, but it's being cancelled for registration in many countries. And the Chinese translation of Jeep, Jipu, was a trademark in China, and eventually it was cancelled for registration. The Jipu, the Chinese translation, Jipu, but the English translation, Jeep, is still a trademark in China. So the Jeep car now um, launched a very interesting slogan for advertising, saying not any Jeep is a Jeep. Another example is aspirin, which was a trademark and then became so popular when people say, give me a piece of aspirin, it not refers to this kind of medicine offered by that manufacturer. It refers to any possible painkiller. U-Pen in Chinese, USB drive. It was a trademark, but already uh, been cancelled because it's a generic term referring to any portable storage device. Jeep. Jeep is still a trademark in China, but Jeep in many other countries. So when you ask anyone, give me a Jeep, and then they're not kind of talking about that's the car from that seller or maker, and they refer to that specific kind of vehicle. Bluetooth is still a trademark in English, but the Chinese translation lanyard has been cancelled for registration because it has become a generic term. When you ask any Chinese lanyard, it refers to a short distance communication technology. And WeChat could be a very interesting case. WeChat or Chinese Weixin micro message, it could be descriptive, but well, there's a lot of story behind this case. Um, we might be back to this case later. In addition, a mark would not be registerable if it's purely functional. A sign shall not be registered as a trademark if it consists exclusively of the shape of the goods which is necessary to obtain a technical result. In this case, it's the functionality of a mark shall not be protected under trademark. For instance, for three-dimensional trademarks, this is a very specific requirement for registerable three-dimensional sign. Article 12 of Chinese trademark law provides that a three-dimensional sign, which is applied for registration as a trademark, application should be rejected if the three-dimensional sign merely indicates a shape inherent in the nature of the goods concerned, or if the three-dimensional sign is only dictated by the need to achieve technical effects of or the needs to give the goods substantive value. The following case concerning our three-dimensional trademark for electronic shavers is one of the famous examples for you to understand how the non-functionality requirement is examined by the court. In Phillips versus RCP and Arnold, this is a case about a well-known mark or a well-known major manufacturer of three-headed rotary electronic shavers for the international markets. This is a great invention, three-headed rotary electronic shavers, because it's a much more efficient for men to shave. Well, the three-dimensional registration for the three-headed design of the electronic shavers was denied by the courts in the end. The courts was of the opinion that the non-functionality requirements ensures that the shape mark, three-dimensional mark, like other trademarks, are indicators of origins or source of the goods in question. They do not enlarge the scope of trademark protection to cover technical solutions for the goods themselves. Other forms of intellectual property, such as patents, designs, and copyrights, are available for the protection of particular rights of defined scope and limited duration in specified aspects of the goods themselves. There is another case in China which is about the three-dimensional design of a bottle for perfume. The Christian Dior applied for a three-dimensional trademark for its bottle used for perfume, on the grounds that this design is unique, looks nice, a lot of philosophy applied to these products, and after years of use, and the consumer already recognize this is a key feature of our products. This case being appealed from Trademark Office to TRAB to and the courts of first trial to all the way to the Supreme Court of China. Starting with Dio, the claimant, the Supreme Court ordered the TRAB to review Dio's trademark application again, specifically stating that the TRAB should reconsider the issue of distinctiveness, and where it is possible for the bottle shape to acquire distinctiveness through use in the marketplace. So basically, Christian Dior's application for a three-dimensional trademark of this bottle for perfume has been supported by the courts in the end. Functionality could be a very complicated issue actually. In YSL versus Lupton, YSL asserted that in general terms, a product feature is functional, right? And it cannot serve as a trademark. In this case, the bottom of the woman's shoe is in red. That red bottom of a woman's shoes is purely functional. It is essential to the use or purpose of the article, or if it affects the cost or quality of this article. So here, the red bottom of the shoes is not for is primarily for functional purpose, making it attractive to consumers, making it this product looks nice. But the Second Circuit of the United States decided that the functionality of a mark can be demonstrated by showing that the mark has either traditional utilitarian functionality or aesthetic functionality. The functionality defense is an affirmative defense against infringement accusation. But in this case, the courts of appeal, the Second Circuit, was of the opinion that the red sole mark merits protection only as modified, and because YSL's use red also on a monochromatic red shoes does not infringe on the mark as modified. We need not and do not reach the issue of consumer confusion and functionality examination. So anyway, in the end, the courts suppose that Lupton could maintain a trademark in the red sole mark because it could be distinctive as won't necessarily being utilitarian or aesthetic functional.